We don't accept or consent to the law, the orders. So
All right.
we don't
What's the?
that.
I'm sorry, sir.
We don't consent to that unless it's proven to us in writing that there is
Mr. Martinez, I'm saying that I found proof sufficient. You can appeal if you don't agree. Okay?
Well, no, that's not the law. The law says that we have to go
It is the law, Mr. Martinez. It's 725 Urban Oaks doing business as Urban Oaks versus Jose Martinez, Nicole Lewis, and then the other occupants of 6725. So who do I have on behalf of Urban Oaks?
Keith Wolfshall, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Do I have someone for our first defendant, Jose Martinez?
Yes, we're here as a special appearance only, and Nicole is also in a special appearance as well.
All right. Mr. Martinez, what is the reason you're saying it's a special appearance?
This is a special appearance because we are challenging jurisdiction and we do not participate in legal contract.
Okay. What is the reason you don't think the jurisdiction exists?
Because it has to be proven. Whenever they're challenged.
That's not a jurisdictional thing. Jurisdiction is either it's something I can't hear, but evictions are solely the province of a justice court. So the only other jurisdictional issue would be if the property is not located in the precinct. To your knowledge, does that address physically fall within the bounds of precinct 3?
I don't believe it does. That there's no personal jurisdiction. There's no personal jurisdiction. There might be subject matter, but in order to hear a case, you have to have subject matter and personal jurisdiction at the same time.
Mr. Martinez, if you're appearing in court, you've been served, and if you are indeed an occupant, then that would be sufficient for them to have personal jurisdiction and for the court as well.
That's why we're challenging jurisdiction, and the law says that whenever we challenge jurisdiction, that the court cannot proceed unless they provide to us, both of us, Nicole Lewis and Jose Martinez, proof that y'all have any jurisdiction.
All right, well, I'll take the information from Urban Oaks, but we'll find out. All right, then. Mr. Wolfshall, please tell me first, why don't we address the jurisdictional issue? Is this property located within the bounds of Precinct 3?
According to the maps of Travis County, yes, Your Honor, they are.
Internet just like a hall. I can't hear
the maps.
Mr. Wolfshall, I was not able to understand you. You broke up a lot.
I'm sorry, Your Honor. Is this any better?
That's better. Okay. Tell me about location. Is it in precinct 3?
My apologies, Your Honor. Can you? Okay, thank you. Yes, Your Honor. According to the maps of Travis County, the precinct, this property does lie within the precinct of precinct 3, jurisdiction of precinct 3. We'd ask the court to take judicial notice that 6725 Urban Oaks is in this precinct.
On Circle Road at Commerce and William Cannon? Mr. Wolfshall, is that the address?
I'm sorry, Your Honor, you're breaking up on me?
Is the address 6725 Circle Road?
I'm sorry.
Mr. Wolfshall, your internet
I'm sorry, Your Honor.
Is bad.
I'm sorry, Your Honor. The address is 6725 Circle S Road, Austin, Texas, 78745.
All right, I pulled it up on the map. That is within precinct 3. So we have both personal jurisdiction and subject matter jurisdiction. So Mr. Martinez, Mr. Lewis, I do find that jurisdiction exists within our court. All right, Mr. Wolfshall, I'm sorry, sir?
We don't consent to that unless it's proven to us in writing that there is jurisdiction.
Mr. Martinez, I'm saying that I found proof sufficient. You can appeal if you don't agree. Okay?
Well, no, that's not the law. The law says that we have to go to the
law, Mr. Martinez. As long as you are showing up, the plaintiff need only show me that they have served the defendant in the result, which you've not denied that you are Jose Martinez. He has established for me that is an eviction wholly within the precedence of a justice court, and that the address for which the eviction is sought is one which is in my jurisdiction. That is all that is needed.
But also it says that we don't participate in legal contract, and that would be.
Mr. Martinez, are you currently residing in the apartment they're trying to evict you from?
I don't understand your question, and I don't understand your jurisdiction.
Mr. Martinez, I'm going to ask that you just be silent and let me go through.
This is a classic sovereign citizen miscalculation. Legal psychologist research shows that when someone believes jurisdiction is a magic shield, they stop defending the actual facts. The strategy feels powerful because it rejects authority, but legally, it hands control to the other side. Once the judge moves past jurisdiction, silence here doesn't protect them. It removes their last chance to challenge evidence.
The plaintiff's case, and then I will answer all of your questions for you. Okay? All right, Mr. Wolfshaw. So it's an address that's in the precinct. What's the reason the eviction's being sought?
Your Honor, this is an eviction for non-payment of rent.
Non-payment. Is there a written contract with the defendants?
There is, Your Honor. It was entered into on November 6th, 2024, and it expired on October 31st, 2025. We're now in the secondary phase.
Mr. Wolfshaw, is that contract with Jose Martinez and Nicole Lewis?
It is, Your Honor. There is a copy that was provided to the court as well.
How much is the monthly rent for that lease?
$1,464.
All right. Any subsidy?
It is not Your Honor.
Mr. Wolfshaw, you broke up. Was that a yes or a no?
No. The last question is, it is not subsidized, Your Honor.
All
It
right.
is not subsidized.
What months of rent have been unpaid?
October through the present,
Is this a CARES property?
it is, Your Honor.
And when was the notice provided?
September 10th of 2025 I apologize, Your Honor. I did not write that down. Give me just one moment. Let me make sure I'm telling you the truth. All right. It was by first class and certified mail on September the 10th, 2025. It was also a 30-day notice to vacate.
All right. To your knowledge, the tenants have not vacated?
They have not vacated, Your Honor.
All right. What unit number is it, Mr. Wolfshaw?
Yes, Your Honor. That is going to be unit 1240.
All right. Mr. Martinez, Ms. Lewis, good morning. Mr. Wolfshaw says that you have a lease with the apartment complex for unit number 1240, and he provided me with a copy of that lease. Do you recognize this document?
Yeah, that contract is expired.
Is this a contract that you entered into, Mr. Martinez?
That's not the original one. The original one was signed in wet ink. That one is signed by electronic signature.
All right, so you have a contract that you signed. Is it for the apartment number 1240 there at 6725 Urban Oaks?
It was, but it's expired.
All right, are you still currently residing in unit 1240?
Yes, we are.
When's the last time you paid rent?
I'm not sure.
All right, the landlord here says that the rent is $14.64 a month. Is that correct?
I'm not sure because we were getting assistance from a foundation for the
Per
home.
your lease, what does it say in the lease that you said you signed? On this one, I see it to be $14.64.
Right. That's probably the foundation was paying for that. So they were the ones that were doing all the paperwork for us.
Do you have any proof that they are paying the rent on your behalf? Because the lease says that y'all owe it.
Yes, we do have proof. They were sending checks from City of Austin Foundation for the Homeless to the apartment complex that they were paying the rent.
All right. Do you know if rent has been paid for October?
I'm not sure.
Ms. Lewis, do you know if rent has been paid on behalf of October?
I'm unaware.
All right. And Mr. Lewis or Mr. Martinez, Ms. Lewis, have either of you made payment, or do you know if payment has been made for November?
We're not sure.
All right. Well, they do find the landlord has met their burden then to show that per their information in the ledger and the lease, rent remains unpaid for the past 2 months. Mr. Wolfstrom, are you wanting to prorate the rent through the hearing or through the appeals deadline?
Your Honor, just for today, I calculated that as $3,028.
All right. So you are prorating?
Yes, Your Honor, we're prorating.
Today is the 18th. So for 18 days, I got $48.80. So that's $878.40. So with that and the $14.64 for October, judgment for the plaintiff, $2,342.40. If either party wishes to appeal, We'll put that at just the 1 month of rent. That'll be $14.64. Ms. Martinez, Ms. Lewis, you both have at least 5 days to appeal before the landlord can seek a writ of possession. We will send you the information related to that. I'll highlight for you, for all parties actually, in a non-payment case, you may be able to appeal, and if you've been receiving assistance from a rental agency, you might even qualify to appeal for free. However, if you want to stay in that apartment while the case is being heard to another court, you do have to pay full rent of $14.64, but you pay it to the court, and we'll send you specific information about that. All right. Any questions, Mr. Martinez, Ms. Lewis?
Okay. Yeah. We also submitted a VAWA case, Violence Against Women's Act, that was also violated back in July. And we submitted the VAWA Act. So they're in violation of the VAWA that prevents us from being evicted according to VAWA Federal Act. And we submitted it and they did not respond or help us on that VAWA Act.
All right, Mr. Martinez, unfortunately, that does not work as a defense to non-payment. I would absolutely encourage you to reach out to legal aid with that issue and with the others and see if they can assist you. You have at least 5 days. If you take no action sooner, day 6, the judgment becomes final. All right.
We don't accept or consent to the orders. So.
All right. Well, Mr. Martinez, whether you consent or not, that is the order of the court, and it will become final, and the judgment would be sufficient for the landlord to move forward with a writ of possession and removal of you and your property. So please contact legal aid in the next several days to see about an appeal. All right.
Well, we don't call legal aid.
Good luck. All parties are excused. Thank you. Mr. Wolfshaw, do you have any other matters today?
Yes, Your Honor. I have 4 more cases.
You'll just stay on the docket then, and we'll go through them in our order.
Yes,
All
ma'am.
right. All parties
Sounds
are
good.
Thank you. All right. Next is going to be cause 25-1543. That is CLPF Lantana Ridge versus Bradley Anderson, Emily Culp, and the other occupants of 6636. Who do I have for Lantana? Anyone here on behalf of Lantana Ridge?
Keith Wolfshall again, Your Honor.
Oh, okay. And who do I have on behalf of? First, it's Bradley Anderson.
She said we could do it together if that's okay.
Oh, that's fine. I like to make sure you're both here, right?
Yes, ma'am.
One
Yes, Your Honor. We both are here.
Yes, ma'am.
Are you Mr. Anderson?
Yes, ma'am.
Okay.
Your
And then do I
Honor.
have Emily Culp?
Yes.
Good morning to you both.
Good morning.
All right. Mr. Wolfshaw, please tell me why this one's sought.
This case is for non-payment of rent, Your Honor.
What's the monthly rent?
The monthly rent is $1,893.
$1,893. Any subsidy?
It is not subsidized.
All right. What month's unpaid?
Currently for October and November,
Was this a CARES property?
it is not a CARES Act property.
And then when was the notice to vacate?
October 9th, 2025, a 3-day notice to vacate sent by certified mail, return receipt requested.
All right. Good morning, Mr. Anderson, Ms. Culp. Mr. Wolfshaw's here is representing the landlord, Lantana Ridge, and he said this case is about finances. He said the flat monthly rent, so the basic rent, is $1,893. Is that correct?
Yes, ma'am.
Okay.
Yes, ma'am.
All right. And then he said that rent has remained paid here now. It's a recent thing, but for October and November. Is that also correct?
Yes. Correct.
Yeah. Well, Mr. Anderson, Ms. Culp, with that, the landlord meets their burden for one of these cases. But do you have any questions? Is there any information I can provide or anything you wanted to share with the court?
Well, we did, but hearing everything else, I guess we don't have any options. So to ask for an extension, we wanted to ask to split up and pay over the next 2 months and even it out and become whole. We were in financial troubles and we want to make it right. But does it sound like we can?
No.
Legally, the landlord does not have to allow that. So I always say that once a contract says it's due, the landlord on the 10 minutes after you're late the first day, they can move forward with their rights to seek an eviction. Will they? I don't know. Certainly they have sought an eviction and they're winning their case today. You do have a few days here before it becomes final. You can speak to the landlord. Sometimes I've had tenants tell me that after the eviction hearing, they recontact some of those legal services or church programs. And because you have been evicted, sometimes those services can kick in or can provide assistance that they couldn't when you were kind of, getting into the situation. That's anecdotally, that's not legal information. That's, it's just information. Okay. So Ms. Cole, Mr. Anderson, I'm gonna give you the final numbers and then a little bit of information on time. And then certainly if you have any questions, I want to answer them. Mr. Wolfshall, I calculate for prorated rent through today, I calculated 1135. And when I add that to the 1893, I get a total outstanding balance of $3,028. And so that is
That was
what
my calculation.
fantastic. Thank you. So that would be the judgment today. So it's $3,028 plus the cost of court. So Ms. Cole, Mr. Anderson, the judgment you get says 3028 plus cost of court. Now, when you move out, you may very well get a bill from the landlord that has a greater number because that bill can include late fees, the rest of the month of November, utility bills, anything your lease said you owe can still be billed. The law for eviction court says the landlord can only ask the court to award actual unpaid rent and cost of court. So that's just an explanation for why numbers may look different when you see them. But today, the official judgment is $3,028 plus cost. Either party can appeal. I would put the appeal bond equal to 1 month of rent. So it's $1,893. Ms. Colt, Mr. Anderson, you have at least 5 more days before the landlord legally can remove you and your items. They have up to 60 days to do that. So speak to your landlord. They may have a sense of how long they're going to give you and what it is. Now that's assuming you don't take any actions beyond that. All right, but you have at least 5 more days, potentially longer.
What?
I'm sorry, Mr. Anderson.
I'm sorry, I apologize.
Oh, Ms. Culp, I know it's very
If-
exciting. I recognize and appreciate you're here.
I've never been in this position. I'm
During
so
our
sorry.
5 days,
Yes, Mr. Anderson, during the 5 days.
if we, you know what, I don't know what's,
No, we've never been in this position. We didn't know how it worked.
Contact
I
any
think
and
he's
all
trying to
of
ask if we, like, in the 5 days, if, I guess it's up to them, our apartments, if we paid them, would they let us stay? I guess that's what you're trying to ask.
And
yeah,
that is, Ms. Culp, you're correct. Even if you today came to the hearing and said, I have all of the money, the late fees, the utilities, I can pay for the rest of the year, the landlord can legally say, no, I want you evicted and I want my money. They don't have to, but legally, I could not tell them no if they said, Judge, I want my money and I want to evict them. Even if you were like, here is all the cash, they do not have to do that. So reach out to them into legal aid. Again, you absolutely, though, have at least 5 more days before anything would change. Okay.
Okay.
Good luck to you both. Thank you for coming. I appreciate that. Mr. Wolfshall, do you have is there anyone in particular, if they wanted to reach out just straight to the landlord there on site?
Yes, Your Honor. Ma'am,
Mr.
Hello?
Wolfshall, the internet is lagging a lot.
I'm up with will they allow them to pay?
hello?
Yeah, Mr. Anderson,
thank
Mr.
you.
Wolfshall's internet is lagging. We didn't hear
Your
any of
Honor?
that, Mr. Wolfshall.
No. My sincerest apologies, Your Honor. I'll try to talk louder. The notes that I have shows that they will still accept the funds and allow them to stay if they bring the entire account current.
All right,
So-
Ms. Cole, that's some extra information. Landlord says that they're not opposed to trying to work with you and settle if y'all can come up with the money. So reach out to your landlord and see what still can be done. Okay.
Okay.
All right. Very good luck to the both of you. I understand this
Thank
is
you. I'm sorry.
surely it's emotionally draining. So I hope you find better luck in the future. Thank you for coming.
Thank you.
All right. All parties are excused. I do appreciate it. And Mr. Wolfshall, thank you. That's good to know. All right. Then we will be with 25-1552. That's Pillar Holdings LLC versus Edward Charles Horton Jr. Who do I have on behalf of Pillar?
Grayson Balthus.
Good morning, Mr. Balthus. And are you counsel, agent, owner, manager?
Agent.
And do I have someone here on behalf of Edward Charles Horton Jr.?
Yes, ma'am. I'm here, Your Honor.
Good morning, Mr. Horton. Thank you for being with us.
Hey, good morning.
Mr. Balthus, why is this eviction sought?
We're seeking the prorated rent due at move-in along with the additional deposit needed for approval.
I'm sorry, what's the reason you're evicting him?
The prorated rent due at move-in along with the additional deposit that was requested for the approval of application, that the payment was returned and we did not receive the full payment.
It sounds like you're telling me non-payment is the reason you're wanting to evict him.
Yes, non-payment,
Got it.
sorry.
He didn't pay. Okay. So how much should he have paid per month for the rent under the lease?
It is $1,573.
Okay. I can't do anything about a security deposit. If he didn't pay that, that's something different. I talk about rent and eviction. Okay. So $1,573. What months has he not paid the rent?
So he has not paid for November and then prorated amount in September and move in.
I think you're reversing that.
Because
You
he
get
got,
all of September, you would get prorated November because today is November 18th. So I can't give you money for the rest of the month.
yes.
When
So
did
this
he
one's
stop?
kind of tricky because he received a concession for a month free in October.
Mr. Balbus, I'm going to ask you a little bit easier.
Okay.
What's the first day he didn't pay rent?
So, like I said, his move-in payment bounced. So that would have been November 23rd or September 23rd,
When did he move in?
September 24th.
Okay, and how much did he owe for September?
It was a prorate of $367.03.
All right, and then how about October? He owed all $1,573.
Yes.
Did y'all give him a concession?
So he would have to pay it back, but he did
I-
receive that concession.
Just stick to my questions, Mr. Balthus.
Okay.
Y'all offered him a concession, but he signed the lease. He paid prorated for September, and he didn't have to pay for October because he was supposed to pay November and a deposit.
Correct.
Okay, so he moves in September. He doesn't pay September.
Correct.
He gave you a check for the deposit. That check later was insufficient.
Mhm.
Okay, so he didn't pay October because he thought he was covered by his deposit, which later became insufficient.
Correct.
How about November? Did he pay November rent?
No, ma'am.
Was he supposed to pay for November, or was that also a concession?
He was supposed to pay, yes.
Do you think it or do you know it? What's the lease say?
No, he was supposed to pay November.
Okay, and November. All right, when did you give him the notice to vacate?
It was delivered on October 10th, and it was a 3-day notice to vacate.
All right, so not a CARES property.
No.
All right. Did you notify Mr. Horton that his check for the deposit had been insufficient?
Yes,
Has he come in to repay it?
he partially did.
How much has he paid?
1,000.
At this point, Mr. Balthus, since September, October, and November is the only amount of money that you've received from the defendant, that $1,000.
Correct.
All right.
Good
Mr. Horton, good morning.
morning, Your Honor. I paid the $1,000 like you said, but I also paid the remaining balance of my rent.
When did you do that?
I did it yesterday.
So you paid it late?
Yeah.
Okay, so there's
Yes,
no
ma'am.
doubt that you didn't pay it on time. So if I'm
No. I
non-payment,
did not.
it's correct. You haven't paid it on time.
No, I paid it late. I paid it yesterday before the hearing.
Okay, Mr. Horton, is it correct that under the lease your rent is $1,573?
Yes, ma'am, that is correct.
All right. Now, when you signed the lease, did the lease say that you would get a concession that October would be free?
Yes, ma'am.
And did you have to pay a deposit?
I did.
I'm sorry, sir?
Did I have to pay a deposit? Yes, I
Okay.
did.
And did you pay the deposit?
Paid partial of the deposit, but I did not pay all of it because once I paid the deposit, one of my payments came back, but the $1,000 it went through.
Okay, so let me ask you this, Mr. Horton. I don't hear any dispute that payments haven't been made correctly or on time. How much in your statement today, you're telling me under oath, how much have you given in full funds to the plaintiff?
Well, my payment today and And $1,000, so like $3,000.
So yesterday you made a $2,000 payment.
Yes.
And how did you make that payment yesterday?
I made it with my account. I just got paid.
Mr. Beltis, can you see if any additional funds have come in from the defendant?
They have not.
Mr. Horton, do you have any proof of that for me today?
Yes. If you go to, well, if I go to my yeah, I could. Can I share my screen?
No, I don't want you to share your bank account. Here's what I'm gonna say. I'm gonna give them the award. If you go to them and tell them I've already paid it, then the judgment is reduced by that amount, okay?
Yeah, I paid it. I just need to show you.
I don't know, right? Cash is always king. You paid it online. People have reversed things after we've done it. So I'm going to go with the numbers that I got from the plaintiff, which are not in dispute. And if it turns out you've gotten them more money, then you don't owe them as much as the judgment says, right? If you've given them the money and the money clears in 3 days, then you don't owe them that. But there's no dispute that rent hasn't been paid in full on time.
Yeah, I paid
Okay.
it.
So let's see, 367. So it's 1573 a month. In the month of November, we got 30 days. Today is the 18th. So for the month of November, I have $943 as of today. So 943 plus the 1573 for October and the 367 for the end of September is total of 2883. And both parties agree that at least $1,000 has been provided to the landlord. So judgment for the landlord, $1,883 plus your cost of court. For appeal, either party can appeal. It'll be $1,573. That's equal to a month of rent. Now, Mr. Horton, Mr. Beltis, go back and check your math again. If Mr. Horton made payment last night and that payment is good and goes against it, then essentially he just owes you a little bit for court cost. But that does not change the outcome of the case, Mr. Horton. The fact that you may not owe them any money doesn't change the fact that you didn't pay it on time, and as a result, an eviction is being entered against you. You can still appeal that. You have 5 days. Ask him, Mr. Beltis, if he thinks I've done something wrong or math is weird. All parties can appeal. If no one does anything, that judgment becomes final on day 6. All right, Mr. Horton.
Okay, so I paid. So do I just talk to my property manager and go from there, or what?
You can talk to the editor. You can talk to legal aid. I can't tell you if you should talk to them. I'll just say that you have those options. But if you don't do anything,
I was told, if it's paid, then I'll be fine. So I mean,
Mr. Horton, I don't even told you that. Legally, what I can tell you is that even if you gave them all the money, the landlord can still tell you to move out because you've been evicted.
Yeah, but I'm saying that was per the apartments.
The apartment today told me they wanted to proceed.
Well, that's not one of the assistant managers told me if I paid, I'd be fine.
I am the assistant manager.
Okay.
No,
Mr. Horton,
it wasn't him.
Mr. Horton.
It was the other guy that I spoke to.
As of today, the eviction is final, and unless you appeal or the landlord sends me something that says this was a mistake, it's going to become final on day 6. So please do not hesitate to reach out to any and all of the people that you think can assist you today. Okay?
I mean, I paid. So what? So I'm just trying to understand. I paid.
And I'm
do
telling
I still
you,
have to? Like,
even
that's what I'm trying to make sure.
You still got evicted because you didn't pay on time.
Even though I paid before the court date?
You didn't pay on the 1st. You paid on the 17th. That is 2 full weeks after it was due. If you're my employee, if you work for me and I tell you I'll give you your check in January and you can't pay your Christmas presents, you're probably not going to want to work for me. The landlord has said you didn't pay on time, and you've acknowledged that you didn't pay on time. The fact that you may have paid up now doesn't change the outcome of the eviction. Unless the landlord tells me something in writing within 5 days, or you appeal and win on appeal. But paying late is never a defense, and it never excuses the violation of the contract. Please contact legal aid to get advice, Mr. Horton, because that's as much information I can give you. Mr. Beltis, do you have any questions?
No, thank you.
All right, good luck. All parties are excused. Thank you.
This hearing shows how sovereign citizen thinking fails not loudly but mechanically. The tenants focus on consent, jurisdiction, and contract language, ideas meant to block the court entirely. But eviction court doesn't operate on belief. It runs on checklists: address, service, rent ledger, lease. Once those boxes are checked, ideology stops mattering. Notice the pattern across the docket. In the first case, rejecting jurisdiction eliminates credibility early. The judge stops debating theory and starts calculating rent. In the later cases, tenants don't reject the system. They misunderstand it. Paying late feels like fixing the problem. Legally, it isn't. The violation already happened. The eviction isn't about money anymore. It's about timing. That's the quiet danger. Sovereign arguments promise control without participation. But courts don't require agreement. They require compliance with procedure. Every time a defendant refuses to engage with the real issue, unpaid rent, deadlines, notice, the court narrows its focus. Options shrink. Appeals get harder. Outcomes lock in. This isn't about being right or wrong philosophically. It's about how systems behave when you test them with refusal instead of strategy. The law doesn't chase consent. It documents non-compliance and moves forward. And once that happens, the most expensive words in court aren't "I disagree." They're "I don't understand why this still happened."